talk on my book about construction of guilt in China. It's a great privilege to come to this place to give you a talk about the story of Chinese criminal justice. So maybe I shall start with the reason why I want to have this project, why the construction of guilt in China. So this goes back to the time when I first encountered a contested trial in Chinese court. Rather than looking like the TV dramas, you have the cross-examination between the prosecution and defense lawyers, asking lots of questions of a witness. All I saw in the real criminal trial was a reading out of the case dossier by the prosecutor and the defense lawyer. So prosecutor just read pages of a document, and then the defense lawyer, after the prosecution's presentation, just keep on reading his document. And there was no cross-examination because there was no witnesses actually come to the court to testify. So that was a typical phenomenon in the Chinese criminal trials. And that phenomenon has been widely recognized by Chinese scholars and also many people who are familiar with the Chinese trials. Because over the years, lots of statistics have been showing that less than 5% of witnesses actually come to the court in China to testify. So there were lots of research for decades have been studying why witnesses do not actually come to the court to give their evidence. And the reasons including, for example, witnesses are worried about their personal safety, like, concerned about their revenge of the suspect, or some judges might be to rely on written dossiers to give judgment, and also some other concerns like financial difficulties for these witnesses to travel to the court, etc. But for me, the story of witnesses not come to the court obviously is very interesting, but I'm more interested in the other side of the story. If witnesses do not actually come to the court, what do judges rely on to make a decision? So in the Chinese court, the decision is based on the case dossier. That is a neatly bounded case document passed down from the prosecution to the judge to make the final decision. So my question was the case, are the case dossiers really reliable? How can the judge make the decision just based on this written document? Are they truly safe to make that decision? So that's my research purpose, and it's a slightly different perspective from the previous interest of the scholarly interest. So that goes back to, so that's my research project was. And for, to achieve that project, I did some empirical research in China. So for example, since 2012 and 2013, I have a participant, I conducted participant observation in the prosecutor's office for over a period of 6 months. And then I interviewed a number of judges, prosecutors, defense lawyers, and police officers. And that was a very useful exercise for me to got my first-hand evidence of how the criminal justice was actually being conducted by those people. So I was able to follow the prosecutors around, listening to their conversation with different legal actors, their interactions with police officers, with defense lawyers, and going with them to the court to hear the trial, etc. So that was a very interesting experience. And that experience helped me to understand the truth-finding process of Chinese criminal justice. So with regards to truth, every country has its own definition of truth. And we know that, for example, in adversarial system, the truth is constructed by the prosecution's case. So the case for the prosecutor and also the case for the defense. And then they put forward these two sides of the facts, and then the court make a neutral decision. So that's the competing version of the truth in adversarial systems. Whereas in inquisitorial system, we know that it relies on this neutral judicial officer who has a judicial status to investigate cases and gather evidence in the neutral and disinterested way. So that's a slightly different way of constructing truth. But in China, truth is a very important concept. For example, in the criminal procedure law 2018, it made it very clear that truth is has to be the criteria for all the criminal process. This including investigation, prosecution, and the trial, and only evidence that is regarded as fundamentally truthful can be admitted to the court. And also, defendants must collaborate with the police in order to tell the truth. And for that, they don't have the right to silence. So truth is regarded very important. But what actually does truth mean? So, so every legal actors have their own understanding of truth. And when I was in the field side, I started to understand the truth, is not as objectively projected as this legal actor actually saw. So for example, in some of the case dossiers which I had access to review, I found that the police officers who have seen the truth, which was actually constructed from people who firstly reported the case to them. So usually their stories are based on the narratives of the victims or witnesses who reached them in the first place. Usually witnesses, usually victims and sometimes witnesses. And based on their conversation and narratives, they built up the initial official contemplated truth. So for example, in this case dossier, I found that the witnesses' statements are strikingly similar to the interrogation record, which was the story given by the suspect. And if you look at the narratives of this statements, you can say there are significant overlapping of this, the way that the language is used, the command of the language, the words that have been selected. So that's just a literal translation of the case dossier, but just to give you a taste of how similar this the version of truth which has been presented in the case dossier. Now there are significant overlapping. So what is truth from the prosecutor, for the police point of view? Truth is a way that they understand the case. So when the when the witnesses or victims reported the case, they will start to investigate the case. And based on that, they will start to formulate their own contemplated version of truth. And that truth will be further being repeated and being corroborated in further evidence. So on one occasion, I asked the police officer and asking them, why the language used in the statement are so similar. And the police officer just explained to me that they have to determine the investigation direction at the very beginning of the investigation. So the initial count reported by the victims and informant is a cornerstone of the investigation, and later evidence must reflect on the victim's account. And this has been repeated again in later when I ask similar questions to the prosecutor, who are very familiar with the way the case is constructed. And they explained to me that sometimes the police officer would deliberately tailor the suspect's statement to the victim's account in practice. So they would force the suspect to say the same thing as the victim said to them, and to ask the victim initially and then interrogate the suspect in a way that the suspect's statement can dovetail with the victim's statement. So they deliberately create this overlapping. So you may wonder why they wanted to collaborate everything. Why do they want to create this evidence, which seems to suggest that one piece of evidence is supporting another? Well, the reason why was because of the criminal procedure law. According to Article 200, that according to the Article 200 criminal procedure law, that the conviction can only be made if all the evidence are supporting each other and leading to a single outcome of the guilt of the suspect. So if the evidence, for example, different pieces of evidence are directing at different facts, then the courts would be very difficult to make a decision, because if you think about it, no witnesses actually comes to court. The case dossier is the only documents that court have to rely on to make a decision, and it's really hard to ascertain the facts if the facts themselves are not unified in a certain way. So that's why they, when the cases are constructed, the police started to consciously to align the facts with the facts from different statements to make sure that they're only pointing to the one outcome, that is the guilt of the suspect. So this seems to be supported by other kind of evidence which I have gathered during my field work. So, for example, on one occasion, I overheard the conversation between a police officer and the prosecutor, and the prosecutor was not very happy with the case dossier, because he, started to use this very harsh language to the suspect, and saying that I have to warn you, if you keep making all the details exactly in the same, making all the different counts exactly the same, the truthfulness of the statement will be doubted, because they are too overlapping and it looks like false. And he keeps give them education that sometimes witness cannot remember everything. You have to make it natural, make it create some kind of discrepancies. That actually makes evidence more convincing. If you try to match everything, that will be the contrary. So that really shows the evidence that contained in the case dossier is deliberately made, rather than actually a reflection of the people's statements sometimes. So this again, so this was how the official version of truth has been contemplated by the police officer. And once the police officer has decided what is the version of truth should be, then this would be consolidated in the case dossier. And one of the ways to consolidate such case facts is through the confession of the suspect, which is reflected in the interrogation record. So during one of the interviews with defense lawyers, the defense lawyer was very unhappy, because he told me that when he had a conversation with his client said he did confess to the police officer, but the police officer did not write down his words, because the police officer believed what he said did not conform to the direction in which the investigation was going. So they did not even record it. So we can see that police officers are consciously selecting the type of facts and editing, and also choose what facts can be used in a case dossier in order to present a coherent account of the facts. So And that's no longer, is not very pleased by some of the clients. And indeed, that sometimes when I was with the prosecutor and we went to the detention center to interview some of the suspects, and the suspects just reported that they are not very happy with the way police transcribe their account into the written form. And if I don't know how many field workers have done similar work before, but when I first looked at the case dossier, I was very shocked because some of the accounts were really unreliable, in my opinion. And this is just one of the examples. So, for example, on one occasion on this slide, you could say the police officer asked the suspect, what have you stolen from the shop? And the suspect amazingly could remember all the serial numbers of the garments, stolen from the shop. And when asked, did you confess the truth? The suspect say yes. And similar stories repeated, not just in this type of stolen. And on one occasion, I vividly remember that one of the victims one of the suspects, could vividly remember all the 16-digit credit card number of the suspect who he stolen from. And similarly, these accounts were repeated again and again in later interrogation records. So clearly, the police officer were just copying and pasting their interviews and then use that again to strengthen and reinforce their statement. Apparently, there seems to be a lot of collaboration between the police officer and suspect in this type of interview. But that's for sure that there has been something a little bit suspicious in this type of a police interrogation. We don't know how the interrogation was conducted because we were excluded from accessing, being directly observing how the interrogation was doing. But just from this type of a statement, you could really see how the case dossier has been constructed. And similarly, that there are lots of statements which is very suspicious in a way that anyone could be able to recognize there's something going on. So, for example, I remember that on one occasion, the case dossier, the duration of the interview was about 7 hours, but the case dossier, but the record was very, very slim. So, for example, about 4 or 5 pages. You are thinking for 7 or 8 hours interrogation, how can you only produce 5 pages of an interrogation record? So clearly, there are lots of editing and the selecting of facts going on in the police interview. Okay, this is just another. For the police interviews, that we could say there's definitely a little bit distortion and manipulation. And I also got a first-hand kind of account from this aspect because they sometimes would complain what the police officer did to them in front of the prosecutor during the prosecutorial interrogation process. So this is just another example. The prosecutor asked the suspect because the suspect protested the statement he initially put down by the police officer. So he said, this prosecutor said you wanted to keep them, the drugs for yourself because you had a quarrel with your ex-boyfriend who wanted to use the drugs. And then the suspect said, no, it was not true. I was just asked to sign. And the prosecutor then asked him, did you sign the record? Then the suspect said, no, they did not let me read the whole thing. The forced me to sign my name. So this type of complaint, this type of complaint was very common, and over probably 10 out of 70 prosecutorial interrogations, I have heard such complaint. They repeatedly say that they were forced to sign their names, and they were not given any time to read their statements. And sometimes the police just being very, very pushy and use lots of harsh language to ask them to sign their names. And indeed, there was very little safeguards for them to get out of that process, because the police interview, including police investigation, are very much insulated from the outside world. No defense lawyers are allowed to access the police interrogation, and there was no right to silence. And we know that there are some recordings available, but the police controls the tape recordings, and they can sometimes, edit and or report that the recording is broken. So they don't need to always faithfully follow the procedure. So there are lots of things that they can do, which is makes a police investigation out of a scrutiny by the judiciaries or other legal actors. So that's a police investigation. And once the police have finished the investigation, then the case will be transferred to the prosecution to review the case. You may think that prosecutors would, be able to scrutinize the police case and vigorously challenge the any procedural irregularities. But in fact, in China, this has not been the case. Although the prosecutor has been portrayed as a neutral legal actors to supervise the whole criminal process, to safeguard the rights of the suspect. But in reality, they are also under lots of pressures. So for example, the prosecutors are subject to an appraisal system. And according to the appraisal system, they have to make sure that they got as many conviction cases as possible. So if one of their cases is very unfortunately being acquitted, that would be a black mark on their record. And it would be very difficult for them to get promoted and get any bonuses, and their salaries will be affected as well. And for that acquittal, the whole prosecution, Prosecutorial, which is a Chinese prosecution service, would also be affected financially or politically sometimes. So the prosecutors are not that neutral as it's originally presented in law. And indeed, when I asked some of the prosecutors, asked them, are you impartial, do you protect the suspect's rights as you are supposed to? And they said, well, according to the law, we're supposed to, and we are trying to do our jobs. But frankly speaking, in China, it's impossible to be a neutral officer. And, our job is to fight against the crimes. So that's their role of the prosecutor. Then that explains how they interrogate a suspect when the case has been transferred to them. So once a police case has been transferred to the prosecutor, they have to do a number of things to verify the case, to make sure that the case is as strong as possible. And the prosecutors would do a number of things. The first thing is that they will check the case dossier to find out, are there any discrepancies of the facts? Are the cases hold water? Are they really, looks legitimate, and are the evidence all look very, lawfully gathered? And is there any procedural irregularities? And are there any problems in this kind of account? So that's a desk work they have to do. Then, in order to verify the story, they would also interrogate the suspect. And their interrogation sometimes is conducted seriously. If, for example, if they need more evidence to be gathered, but sometimes, or most of the times, it's just very perfunctorily done. So, for example, the prosecutor would always ask the suspect at the very beginning, ask a question: did you confess? Are you pleading guilty? And if the suspect say, yes, I plead guilty, then the prosecutor would acknowledge their right choice and give them reassurance that if you plead guilty, you will get mitigated circumstances and you will receive a lighter sentence. But if the suspect, for example, say, I'm innocent, this is, I was forced to confess this because the police officer put a lot of pressure on me, then the prosecutor started to get very angry. So, for example, on this slide, you could say that in a small number of cases where the tension between the prosecutor and the suspect was very high because the suspect did not appreciate the benefit of pleading guilty. So the prosecutor asked the suspect, did you plead guilty or did you tell the truth? Then the suspect said, I did not. I said nothing. Then he continued to persuade him, you commit a crime, which did not really carry a heavy sentence. Then the suspect continued to maintain his innocence, and then finally they will, end up in a very, very unpleasant altercation. And it always ends with the prosecutor wanting to threaten the suspect, to say, if you don't behave, I'm going to impose heavy penalty on you, and you will be the one who actually have to be responsible for your behavior. So this is how the prosecutor reacts when the suspects really maintain their innocence. Sorry, I just lost my train of thought. You were wondering, why the prosecutor wanted to do that. Obviously, this is because of their prison system and how the legal culture looks like, occupational culture in the Chinese proctorate. And in fact, all the prosecutors were very proud of their ability to procure guilty pleas. For example, the prosecutor's office, which I worked with, had a number of female prosecutors. And some of them initially, I overheard from their conversations. When they initially went to the prosecutor's office, they were just ordinary, ladies and talk gently with the suspects. But later on, after a period of time, after the training, they all become very, very dominant and started to use all sorts of language in this in interrogation settings to make sure that the suspects behave. And in fact, if you show your kind of a weakness, not be able to obtain as many guilty pleas from the suspect as your colleagues, it would be same as a sign of a weakness, showing that you are not competent enough to be a prosecutor. So, even though there are a number of female prosecutors, but they are actually more aggressive than their male counterparts sometimes, because they that kind of occupational culture really demands the suspect to make sure that they get a guilty plea. And if someone who refused to plead guilty or challenge the case they initially gave to the police, that would be seen as a challenge of the prosecutor's authority, kind of a very disrespect. They would sometimes take that very personally. And so it would be seen as a kind of deviance rather than just maintain to tell the truth. So it's a deep-seated legal culture in the prosecutor's office, which I found very interesting. So once the prosecutor have made a decision, assessing all the evidence and interviewed the suspect, etc. And then if they think the case is strong enough, then they would transfer the case to the court for the court to decide. And here I need to introduce defense lawyers. Defense lawyers are actually long been regarded as an outsider of the Chinese criminal justice system. They are for a long time, and they have been not been very well protected. So, for example, before last year in August, Chinese criminal legal aid has not been in place. So it was in place, but in its infancy. So, for example, thank you. So, for example, that for a long time, only 30% of the people, 30% of suspects are legally represented. The vast majority of the suspects are not either not represented, or they have to defend by themselves, which sometimes is counter-effective. So for those people who are entitled to legal aid, who were entitled to legal aid before last year, they were only limited to 3 categories. That's people who have some disabilities, such as blind, deaf, or mute, or they are juveniles, or people who are going to be, or due to be sentenced to death penalty or life imprisonment. So only those 3 categories are entitled to legal aid. The vast majority of suspects are not be able to get criminal legal aid. And even for those who do get criminal legal aid, those cases are not always treated seriously by the defense lawyers, because defense lawyers took those cases on pro bono basis. That means they are not fully funded, and they usually are not taking those cases, as diligently as they should have been for their own cases. And also, for those suspects who did retain a criminal defense lawyer, the defense lawyers can do, or what the defense lawyer can do is also very limited. So, for example, there is Article 306 of Criminal Law 1997, which is very infamously noted as a harsh way to silence and subjugate active defense lawyers. So, for example, if the defense lawyer wanted to challenge the prosecution case and started to contact some of the witnesses, prosecution witness, to verify their account, in order to undermine the prosecution case or to construct the defense case, then the defense lawyers themselves sometimes would be in danger, because they would be accused of committing the perjury, and then they become the subjects of the committing the crime, and then they would be arrested and being prosecuted. So because of this law, which is very discriminated against the defense lawyers, not many defense lawyers are willing to take on such proactive, robust defense construction. And for most of them, they only just be able to access the prosecution case to find out, are there any weaknesses in the prosecution in order to challenge the prosecution in case. So you can say this is a very limited way of there's a limitation of what they can do. And there's other obstacles as well. So those obstacles including, for example, meeting their clients in a detention center. It's not always easy, and there's a lot of variations between different regimes. Some of detention centers are very hostile to defense lawyers. So, for example, they would deliberately deny their access and using all sorts of excuses. And sometimes the prosecutors would also refuse access to the case dossier if they think the case is not, sufficiently, the case itself is too sensitive or have some kind of a provenance. So the disclosure of evidence is not always guaranteed. And perhaps most importantly is that the defense opinions are not always treated in the same way at their prosecutor, their prosecutors and their opponents by the court. This then goes on to say the relationship between the prosecution and the court. In China, there has been a saying that the police, prosecution, and the defense lawyer, police, prosecution, and courts are one family, and they are. It's like the police is the old saying: the police is the cook, then the prosecutor just presents the cook to the court, and the court just eat. In fact, whatever the place have been cooked, then the judge would always eat. So, and then the prosecution and the court are always maintain a very close relationship. This is known as the iron triangle, you know, the term which shows a correlation between the three institutions. So, during my field work, I have lots of, you know, on many occasions I have seen that the prosecutors and the court have engaged in, you know, very friendly conversations on phone, negotiating different terms and sentences of certain cases. So the judge, if they have any doubts about the case, they will phone the prosecutor and ask for more details. And from there, they have their, you know, very cordial and friendly conversation, just like you know, old friends, and they will talk about different things, and including how the case is, why the case have some flaws. You know, sometimes they would be the prosecutor would be very frank and say, "Oh, yeah, police didn't do a good job, but you know, can you consider this on that?" So they can negotiate lots of things through this informal way. And then through that kind of conversation, the case decision would be made at that point, and then the judgment would be just a reflection of this predetermined decision of this case. Because no witnesses actually come to the court, we know that this is how things have been done in practice. So all the cases would be predetermined even before the trial, or sometimes after the trial, depending on the judge's agenda. So prosecutors are always well informed of the decision. And for example, if one of the cases has some problem, the judge would first inform the prosecutor either to withdraw the case so that the case would be filtered out of the system, therefore there's no acquittal, or sometimes the judge would just you know, ask the prosecutor to change the case, change a different case, so that the judge would make a decision and to allow the case to be to some using some way to be swapped. So their relationship is very close, and that is to make sure that the conviction rates are always guaranteed. So just to remind you that in China, the conviction rates of the criminal justice system is very, very high. About 99.9% of cases are convicted. So only 0.1 cases, 0.1% are actually acquitted. And this is just another way of another interview, which the defense lawyer was not very happy the way they were treated by the judge, because the judges apparently treat defense lawyers very different from the prosecution. The prosecution evidence will always be admitted unless there are very major flaws. Their evidence would be always used as a basis for the decision. Whereas defense lawyers, when they presented evidence, the judge would scrutinize those evidence, and most of the time they would use all sorts of reasons to exclude this evidence if the evidence itself has seriously undermined the prosecution case. So this is during this interview, the defense lawyer was very frustrated because he thought he got a very strong case, but the judge just refused to admit that piece of evidence. I think, just sort of a shorter time. So I think I would just conclude that this is a story of Chinese construction of criminal cases. So from those narratives, you can see that the Chinese criminal justice system really lacks integrity. We know that in criminal justice, integrity is fundamentally important because that gives the legitimacy of the criminal justice, the moral legitimacy of the criminal justice, so that public can trust the criminal justice and believe that the cases are handled in a fair and reasonable way. But the Chinese criminal justice apparently lack of this moral integrity. And this also tells us the truth-finding process and how the Chinese criminal cases are actually being constructed. It's that although China follows the inquisitorial tradition in large measures. So, for example, lots of procedures are more similar to French system, for example. But in fact, we can see that there's the judge, the prosecutors, they are not entirely impartial. They are more similar to the adversarial system, although the prosecutor, for example, they are one party, they are a party of the criminal case rather than a neutral officer. But unlike the adversarial system, you have the two sides of the story. So you have the prosecution case and the defense case. The defense would construct their defense case to challenge the prosecution case in order to get different version of the facts. But in China, there's only one side of story. And that story is the official side of story. Anyone who is not recognized as official are not formally admitted and being marginalized by the criminal justice system. And so here I would like to liken the Chinese criminal justice process as a official recognition and confirmation of the different of the official conduct. So anyone who is not regarded as official is an outsider and therefore are not formally recognized by that system. And the whole system itself is built on the ideology of control. So as we can see from the story, it is all about the control of the evidence that come into the process. And it's also about the control of the legal actors, like the appraisal system, and how the legal actors should behave and should, ought to work in a certain way, and also control the defense lawyer to make sure that they do not have a significant impact on the decision. So, but this behind this ideology of a control, there is a lack of a control of equality. So the criminal cases are not the quality of the cases are not always up to the standard. As a result, we have seen lots of miscarriage of justice in recent years, and some of the cases are very has shaped the criminal justice system and people in a profound way. And those miscarriage of justice really indicate that Chinese criminal justice is fundamentally weak and unable to effectively to prevent people from wrongfully accused and wrongfully convicted. So innocent people who are not be able to filtered out of the system. And as a result, we can say this criminal justice in China is a control mechanism to control the population rather than a justice that's be able to deliver the justice which we hoped for. So I think I shall stop here.